There's breaking news today in the federal civil rights lawsuit against family court judge Louise E. Goldston, which alleges constitutional violations for her search of my client's house in March of 2020. If you never did see the video of what happened in that case, I'll show it to you here very briefly. Take a look.
Hey guys, I need y'all to talk to me, please. Hey, get out of my property. The only one's back right now is the judge and the deputy. Step off the property.
Yeah.
Step off the property. Judge, can I ask you something real quick before we get started? Judge, can I ask you something before we get started?
Sure.
Come here, I ain't trying to have everybody else listen.
Well, Mr. Lefty, listen.
That's good. I'm asking you right now, I'm putting in a motion to recuse yourself because you're putting yourself in a witness capacity instead of a judicial capacity. There's no search warrant, and a list of everything that we're looking for.
You got a list of everything.
Not today. Not today. I don't know where some of it's at. So you got it?
Straight arrest denied, not timely filed.
I need a search warrant. You won't get in my house without a search warrant.
Oh yeah, I will.
So just today, the federal court issued an order denying the judge's claim of judicial immunity, ordering that the jury trial is on for Tuesday. As the order acknowledged, the West Virginia Supreme Court already found that Judge Goldston's conduct was in violation of the law. The court held. Thereafter, the Supreme Court of Appeals of West Virginia concluded Judge Goldston exceeded her judicial powers in searching Mr. Gibson's residence in violation of the Code of Judicial Conduct, and it cites the West Virginia Supreme Court opinion. Now, this opinion that's out today went on to address Judge Goldston's arguments that she was merely holding a family court hearing inside Mr. Gibson's home, and that she should be immune from liability. The court pointed out the obvious flaws in her argument, stating, quote, "The crux of Judge Goldston's argument is," and this is going to be up at the website at the link, civilrightslawyer.com, brand new, up today. Check it out. It's a fascinating court order, and you don't see much of these. So, the crux of Judge Goldston's argument, the court stated, is that her actions were taken during the course of adjudicating a family court dispute. She contends that, assuming she exceeded her authority, her actions were judicial in nature and hence subject to judicial immunity. As noted, the court examines the nature of the act and not the actor. The nature of the act was a warrantless search of Mr. Gibson's residence and a warrantless seizure of his property. The twofold inquiry is, one, whether a search of a residence was an act normally performed by a judge, and two, the expectations of the parties, namely whether Mr. Gibson was dealing with Judge Goldston in her judicial capacity. Respecting the first prong, does a judge normally execute a search warrant on personally search a residence? To quote Judge Posner, to ask the question is pretty much to answer it. While the issuance of a search warrant is unquestionably a judicial act, the execution of a search warrant is not. Again, I'm reading from the court's order today. I'll continue here. Judge Goldston was not engaged in an act normally performed by a judge. The court continued here. Respecting the second prong, Mr. Gibson doubtless dealt with Judge Goldston in her judicial capacity at the outset of the March 4th contempt hearing. The situation changed markedly, however, once the field trip began. Once Judge Goldston invited herself to the residence, began her warrantless search, and then seized the private property, the die was cast. Nevertheless, Judge Goldston notes, 1, a bailiff was in attendance, and 2, the search was recorded much like a judicial proceeding. And 3, Mr. Gibson and his ex-wife made motions during the process. She asserts all of this demonstrates the parties dealt with her as a judge. The contentions do not withstand minimal scrutiny, the court held, and continues. Mr. Gibson's motion for disqualification, which you would see in the video, arose out of Judge Goldston's acting as a witness rather than a judge. Further, the recording of the search, which Judge Goldston attempted to halt, is in no way equivalent, factually or legally, to an electronically transcribed or recorded judicial proceeding. Judge Goldston recognized as much in her deposition, and he cites a deposition. Judge Goldston has thus failed to demonstrate either of the two required prongs to be able to get judicial immunity. So check out the website again, just posted right now at thecivilrightslawyer.com. You can read the whole opinion and order yourself. Now, Remember, there were also the bailiff deputies and their employer also in the lawsuit. So the court also ruled that the Raleigh County Commission, i.e. the Raleigh County Sheriff's Office, is also going to trial on the issue of whether they adopted and maintained a policy of illegal family court judicial searches of litigants' homes, which ultimately led to the search of Mr. Gibson's home on March 4th, 2020. The court correctly noted that the deposition testimony of these two bailiffs indicated the existence, and indeed continued existence, of such a policy. Now I'm reading from the court's ruling. For instance, according to the record, Bailiff McPeak sought out a Raleigh County supervisor prior to his first home search as a bailiff in the Raleigh County Family Court, seeking assurance that he was within department policy prior to doing so. Bailiff McPeak was told by Sergeant Aaron Lilly that he was authorized to participate and that they, quote, do that from time to time. Even after the March 4th, 2020 event, Bailiff McPeak testified that there has been no policy changes as to family court judges searching parties' homes. Bailiff McPeak, who continues to serve as bailiff for Judge Goldston, has not been instructed by his supervisor, Lieutenant Dave Stafford, to refrain from similar conduct in the future. This continues. Additionally, Deputy Stump, who established during his deposition that he was a supervisor for the Raleigh County Commission, testified that he had visited the homes of litigants with Judge Goldston, quote, numerous times. Deputy Stump explained that the Sheriff's Department policy for bailiffs is whatever policy a judge told him, quote, no questions asked. He noted that even after the March 4th, 2020 incident, there has been no policy change within the department about bailiffs going to the homes of litigants. Indeed, Deputy Stump asserts that, quote, if Judge Goldston told me today to go to the house, I'd be the first one there. Thus, the court held that the record gives rise to a genuine issue of material fact for the jury, respecting whether the Raleigh County Commission had the required municipal policy of allowing officers to participate in home searches with family court judges of the type here challenged. So that's great news that the judge is going to trial, no judicial immunity, and also the Sheriff's Department is going to trial on the Monell claim, on the pattern of practice claim. So the two deputies themselves who are quoted here, they were let out as individual defendants in this order because of qualified immunity. And I've said it over and over and over again, the doctrine of qualified immunity ends up applying where it shouldn't apply in cases like this. Basically, what the court ruled was that, you know, even though it was a civil rights violation for them to engage in this warrantless search, it would be reasonably confusing for a police officer to be ordered to do something by a judge. And that's just enough, you know, it's just enough to arguably be reasonable. Therefore, they're out on qualified immunity. However, the employer is not out on qualified immunity. So that's actually a great result for us that we're happy with. So we're also really happy with the judicial immunity decision. But right afterwards, right after this order came through, they have already, Judge Goldston already filed a notice of appeal to the Fourth Circuit and also filed a motion to stay the Tuesday trial pending her appeal to the Fourth Circuit on the issue of judicial immunity. So I'm currently researching these legal issues pertaining to her request for a stay and immediate appeal, and expect to be filing a formal response with the court by tomorrow morning sometime. So hopefully we'll have an update soon on whether or not the trial on Tuesday is moving forward, and I'll definitely let you know soon as an update comes through and a decision is made.